Okay, if we could now convene the next session. Over to you, Emily. Thank you.
Thank you, Mary. And for those of you just joining us online now, welcome to this next session for the Sydney Centre for International Law Year in Review Conference. My name is Associate Professor Emily Crawford. I will be chairing this session, and I've also been tasked with stepping in for Tim McCormack, who was due to be our keynote speaker, but unfortunately at the last minute had to withdraw. So I'll be talking a little bit briefly, very briefly in a moment, about the Brereton report into war crimes committed by Australian SAS soldiers. I'll turn to that in a minute, but before I do, I just want to very briefly introduce our two other speakers, Professor Catherine Renshaw, who is, I believe, an associate of the Sydney Centre for International Law, but she can correct me if I'm wrong, and longtime friend of both me personally and the university, who will be presenting on the current events unfolding in Myanmar, and Professor Ben Saul, who is our Challis Professor of International Law, who will be presenting on issues with regards to counter-terrorism legislation and counter-terrorism treaties. So like I said, I'm stepping in for Tim, and I'm going to talk very briefly about last year's Brereton report. And I just have to give you advance warning that this really is more in the way of like a summary rather than anything kind of meaningful or insightful. So following the conclusion of Australian involvement in the ISAF engagements in Afghanistan, rumours apparently were circulating that Australian SAS service personnel had committed war crimes during their time in Afghanistan. In response, an internal report was ordered, which was conducted by a sociologist, and it was her brief to report on the organisational culture of the SAS and whether that might have actually contributed to these rumours and whether there was any kind of substance to these rumours. And around the same time, the ABC also ran a series of stories entitled The Afghan Files, which went into much more detail regarding the allegations, which included claims that unarmed civilians and prisoners of war or other detainees had been executed while in the custody of Australian SAS personnel, including one particularly horrifying example of a detainee being executed because the US helicopter that was scheduled to collect 7 passengers, one of whom was the detainee, could only take 6 people. Following the internal report and the ABC investigation in 2016, the Inspector General of the Australian Defence Force appointed Paul Brereton, a Justice of the New South Wales Court of Appeal and a Major General in the Australian Army Reserve, to examine these incidents and rumours in more detail. And it was made clear that this inquiry was a fact-finding process only and not a criminal trial or investigation. So the ambit of the inquiry was to inquire into serious concerns regarding Special Operations Command. They were summarised as being unsubstantiated stories of possible crimes, such as illegal killings and inhumane and unlawful treatment of detainees over a lengthy period of time in the course of SAS deployment in Afghanistan. There was also, part of the ambit was also an examination of the cultural normalisation of deviance from professional standards within Special Operations Command, including intentional inaccuracy in operational reporting related to possible crimes, a culture of silence within Special Operations Command, the deliberate undermining, isolation and removal from Special Operations Command units of some individuals who tried to address this rumoured conduct and culture, and a systemic failure, including of commanders and legal officers at multiple levels, to report or investigate the stories as required by defence policies. So the report was issued last year in November, and it was issued in 3 parts. It included a background and context section, the main body of the report, which inquired into 57 incidents and issues of interest, and the final part, which kind of took a more holistic view, looking at systemic issues such as the strategic, operational, organisational and cultural issues which may have contributed to the creation of an environment in which these war crimes were alleged to have taken place, why the mechanisms of the ADF for inquiries and oversight failed to detect it, and looking into the possible responsibility of commanders. Parts 1 and 3 were released publicly. Part 2 was largely redacted so as not to prejudice possible criminal investigations or trials. So with this in mind, what do we know? What did the report say, and what does that mean from a legal standpoint? Well, for those of you not across the law of armed conflict, it's useful to know a few pertinent aspects of the law. And these are gross simplifications, but they should give you enough of an understanding of why the findings of the report are so significant. So under the law of armed conflict, only combatants, persons who take direct part in hostilities, can be lawfully targeted. Combatants or members of the armed forces can be targeted with lethal force at any time by virtue of their status as combatants. Now, there is no international law prohibiting civilians taking direct part in hostilities, but if they do, they can be targeted with lethal force if they directly participate. But before you target a civilian with lethal force, you need to ascertain whether they are actually taking direct part in hostilities. There is a presumption of civilian immunity from targeting unless you can prove they're actually actively contributing to the hostilities, say through something like carrying deploying a weapon or weapon system, or otherwise engaging in hostile offensive or defensive action that is detrimental to the enemy. Anyone who is hors de combat, anyone who is out of combat because they are a civilian not taking direct part, because they've been taken prisoner, because they have surrendered, because they've been wounded, any person hors de combat cannot be lawfully targeted with lethal force. Doing so is a war crime. And the other part to know at this point is that it's prohibited to order that there will be no survivors. You cannot go into a skirmish, a battle, an engagement, saying that no quarter will be given, that there will be no survivors, that no prisoners will be taken. So all of this basically goes towards the essence of the law being that once the person in front of you is no longer a direct threat, they cannot be lawfully targeted. Now, this is, of course, a massive simplification of very complicated law, but it's sufficient background for what comes next, which is what exactly happened in Afghanistan and what happens now. Well, the good news, if there is such a thing, the report found that 28 of the incidents that were subject to detailed examination, they found that the rumours, allegations, suspicions of breaches of the law of armed conflict couldn't be substantiated. The bad news, the inquiry found credible information of 23 incidents in which one or more non-combatants or persons hors de combat were unlawfully killed by or at the direction of members of the Special Operations Task Group. These incidents included a total of 39 individuals killed and a further 2 cruelly treated, and a total of 25 current or former Australian Defence Force personnel who were perpetrators, either as principals or accessories, some of them on a single occasion and a few on multiple occasions. Perhaps most damning in the report is the finding that none of these instances and incidents occurred in situations that could be attributed to the fog of war, of being under pressure in the heat of battle. As the report states, quote, "The cases in which it has been found that there is credible information of a war crime are ones in which it was or should have been plain that the person killed was a non-combatant or hors de combat. While a few of these are cases of Afghan local nationals encountered during an operation who were on no reasonable view participating in hostilities, the vast majority are cases where the persons were killed when hors de combat because they had been captured, or where persons were under control and as such were protected under international law." Adding to this, the inquiry found that there seemed to have been a significant degree of premeditation or calculation in the acts of the perpetrators through a number of activities, one of which was the practice of so-called throwdowns. Throwdowns are when people carry foreign weapons or equipment typically, though not usually, limited to things that can be easily concealed, like pistols, small handheld radios, weapons magazines, grenades and such things. These were being carried by SAS personnel and being placed on the bodies of people after they'd been killed for the purposes of taking photos of them in order to give an indication that the person killed had been carrying the weapon or other military equipment when they were engaged, and therefore was a legitimate target. So the idea was that you place this weapon on the body after you've shot them to indicate they've been engaged in hostilities, even though before they were shot, there was no evidence that they had been so participating. Other horrifying examples of premeditation include that there was credible information that junior soldiers were required by their patrol commanders to shoot a prisoner in order to achieve their first kill, a practice known as blooding. This would happen after, quote, the target compound had been secured and local nationals had been secured as persons under control. Typically, the patrol commander would take a person under control, and the junior member who would then be directed to kill that person under control would do so. They would then place the throwdown on the body, and the cover story was created for the purposes of operational reporting and to deflect scrutiny. As the report says, this was reinforced with a code of silence. There was also evidence that there was post-engagement fabrication of reporting for the purpose of covering up the facts. Reading the report, you get an overwhelming sense that the problem is not so much the law, but the implementation, that the perpetrators knew full well that what they were doing was contrary to the law of armed conflict, and that those who encouraged and sanctioned the behaviour knew that what they were doing was contrary to the law, and they took steps to conceal the act or to create a false impression about the legality of their behaviour. So ultimately, it seems that the fault lies not so much with the law, but with the culture of the organisation. And as the report says, when it explores why subordinates would be so willing to go against the rules, they said subordinates complied for a number of reasons. First, to a junior Special Air Service Regiment trooper, the patrol commander is a demigod, and one who can make or break the career of a trooper, who is trained to obey and to implement their superior commander's intent. Secondly, to such a trooper who has invested a great deal in gaining entry into the Special Air Service Regiment, the prospect of being characterised as a lemon and not doing what was expected of them was a terrible one, which could jeopardise everything for which they had worked. Thirdly, they were in a foreign environment, far from the influence of the norms of ordinary Australian society, where the incident could be compartmentalised as something that happened outside the wire to stay outside the wire. In that context, some individuals who would have believed themselves incapable of such behaviour were influenced to commit egregious crimes. Now, controversially, the report seems to largely place the blame for this culture of non-compliance with the law with a small group of relatively junior servicemen. As the report says, while it would have been much easier to report that it was poor command and leadership that was primarily to blame for the events disclosed in this report, that would be a gross distortion. Commanders at troop, squadron and special operations task group level must bear some responsibility for the events that happened on their watch, but the criminal behaviour of a few was commenced, committed, continued and concealed at the patrol commander level, that is at corporal or sergeant level. And the report goes on to say, the inquiry has found no evidence that there was knowledge of or reckless indifference to the commission of war crimes on the part of commanders at troop, platoon, squadron, company or task group headquarters level, let alone at higher levels. So that seems to be giving the higher level members of the ADF pretty much a free pass. But then the report immediately goes on to say, by late 2012 to 2013, there was at troop and possibly up to squadron level suspicion, if not knowledge, that throwdowns were being carried, but for the purposes of avoiding questions being asked about apparently lawful engagements when it turned out that the person killed was not armed, as distinct from facilitating or concealing deliberate unlawful killings. And while dishonest and discreditable, it was understood as a defensive mechanism to avoid questions being asked, rather than as an aid for covering up war crimes. Now, that anyone was carrying throwdowns would seem to suggest at the very least that something problematic was occurring, warranting further investigation. If there was knowledge that these were being done, even just for the sake of covering your ass, if you'll pardon my language, this would seem to suggest that further investigation was warranted. And the seeming kind of free pass that the commanders were given in the Brereton report has been highlighted by a number of leading Australian academics like Mel O'Brien and Doug Guilfoyle, who noted just last month that there were several troubling issues raised about command responsibility in the Brereton report. In fact, Doug Guilfoyle said specifically, the idea that it was unimaginable that war crimes could be committed by well-trained soldiers is actually belied by the report itself. A substantial section of the Brereton report is dedicated to a history of Australian war crimes, including during the Vietnam War, of the liberal targeting of Vietnamese citizens and of the use of throwdowns. So the suggestion in the report is that such crimes are not common, but history plainly shows that such crimes are imaginable. So it seems to suggest this kind of tension between this attempt to acknowledge that these things happen, but rarely, and yet there is this history of them happening, and a history, or at least an ingrained practice of trying to excuse it as being acceptable operational practice rather than evidence of anything more kind of nefarious. And when you look in more detail at the Brereton report, when they cite as evidence about what led to its initiation, they talk about persistent rumours of criminal or unlawful conduct, actual knowledge among officers of the practice of using throwdowns, operational reports which used boilerplate language, which indicated or fabricated compliance with rules of engagement, and that this boilerplate language was used so frequently that a new directive was issued so that higher command could understand the actual basis on which targeting decisions had been made, and that there had been local complaints by Afghan nationals of unlawful killings, but they were being dismissed as insurgent propaganda or compensation seeking. All of this seems to suggest that command was less involved in wanting to uncover the truth and perhaps more interested in self-protection than legal compliance. So what then is the next stage? Well, on the 4th of January 2021, the Office of the Special Investigator officially commenced work tasked with conducting criminal investigations into Australian war crimes in Afghanistan. The terms of reference for the OSI are not yet known. There have been investigations into certain personnel for some years now. And in theory, we should be seeing prosecutions going ahead. But if anyone was reading the newspaper yesterday, you would find out that there has been blowback for those whistleblowers. Yesterday, Nick McKenzie and Chris Masters in the Sydney Morning Herald reported that a small number of Special Forces soldiers who whistleblew the alleged war crimes have been issued termination notices, specifically against the advice of both Justice Brereton and the military watchdog. So that would seem to suggest that the people who did actually come forward and state that there was impropriety and criminality going on have suffered more immediately than those people who have actually been responsible for the perpetration of the war crimes. So that is a very brief and amateur summary of the Brereton report. I believe we might hold off to the end for questions, so I'd now like to hand over to Professor Catherine Renshaw to talk about the situation in Myanmar.
Thank you, Emily, and thank you very much, Rosemary and Mary, for inviting me to come again. This conference is always a wonderful event. So, on Monday, the 1st of February, there was what Chinese media called a major cabinet reshuffle and what the rest of the world called a coup d'etat. By the end of the week, the Security Council had released a joint statement urging Myanmar's military leaders to uphold the rule of law and release Aung San Suu Kyi, the leader of the National League for Democracy, who the military had arrested and detained. The military's position is that the 2020 elections, which the NLD won in a landslide, were massively compromised by electoral fraud. They declared a state of emergency under the 2008 Constitution and promised to hold new, fair elections in a year's time. But people in Myanmar remember the last time the military made a promise like this in 1990, following elections which were then, as now, won by the NLD in a humiliating defeat for the military-backed party. The military went on to hold power for another 20 years. So we're in a position of profound uncertainty. The raft of legal proceedings against Myanmar and its generals, which is what I'll discuss today, were undoubtedly perceived as a serious threat and a humiliating affront to the military. One of the proceedings names the coup leader, Commander-in-Chief General Min Aung Hlaing, as a potential genocidaire. The proceedings were launched at the end of 2019 and they babbled along throughout 2020. And in ANU's policy forum today, I've got a piece that suggests the proceedings are a contributing cause of the coup. So what are the proceedings? Well, first, there's the International Court of Justice case involving the Gambia and Myanmar. In late 2019, the ICJ ruled that it had jurisdiction to hear a case against Myanmar for Myanmar's breach of the Genocide Convention in relation to the government's treatment of the country's minority Rohingya population. In January last year, Aung San Suu Kyi went to The Hague, that's the general, not Aung San Suu Kyi, to offer her country's opening statement in response to the allegations of genocide. In a unanimous decision, the ICJ ordered preliminary measures to protect the Rohingya and preserve evidence of possible genocide. Myanmar was ordered to report back to the court in May 2020 and every 6 months thereafter. Since those orders were made, there have been questions raised about the adequacy of Myanmar's compliance. The reports are secret, and there have been questions raised about that too. In December 2020, the ICJ made changes to its rules of procedure and established a committee to assess compliance with court orders for preliminary measures. So the ICJ doesn't want to fail in relation to its preliminary measures orders, given what happened on the only other occasion that the ICJ made these kinds of orders in relation to proceedings under the Genocide Convention. Some of you will recall how in April '93, Bosnia sought and gained interim orders connected to Yugoslavia's alleged failure to prevent genocide. Bosnia returned to the ICJ in August '93, explaining that Yugoslavia was failing to comply and asked the court to grant another interim order. And none of this prevented the Srebrenica genocide in '95. In relation to the progress of the ICJ matter on the merits, in October 20 last year, the Gambia filed its 500-page memorial. Myanmar's counter memorial was to be submitted 6 months later, July 20 this year, but on January 20, 11 days before the coup, Myanmar filed an objection to the jurisdiction of the court. The ICJ's jurisdiction here is thought to have somewhat of a question mark over it. The Gambia's theory of the dispute that exists between it and Myanmar under the Genocide Convention is based on an unreciprocated note verbal of 11 October 2019, in which the Gambia urges Myanmar to comply with its obligations under the convention, and then the Gambia commenced proceedings a month later without any further communication. So is this a dispute as required under the Genocide Convention? The proceedings on the merits are suspended while the preliminary objections issue is decided. We're looking at a delay of perhaps 2 years. On 28th of January this year, the court gave the Gambia until May this year to file its response to Myanmar's objection on jurisdiction. In relation to whether the case against Myanmar will proceed in the ICJ post the coup, there's no question that it will. The case is against Myanmar, the state, regardless of who is in government, and Myanmar will be bound by the eventual judgment of the court. A different question is whether Myanmar will continue to participate in the proceedings. There's an argument that by continuing to appear, the generals are better able to maintain a facade of being a legitimate government, as the present state of emergency being a constitutional interregnum as they insist it is. But in other developments, while Myanmar's participation is now in doubt, it seems certain that other states will join the case. Halfway through last year, the Maldives declared that it would join the Gambia, and a couple of months after that, the Netherlands and Canada. What is certain is that, unlike Aung San Suu Kyi, there's little prospect that General Min Aung Hlaing will appear in The Hague to defend his country's conduct. For one thing, it might be perilous for him to do so because of the chance eventually that he may be subject to an arrest warrant, given the other sets of international criminal proceedings that are currently on foot. One of these is in the International Criminal Court. In November 2019, the pre-trial chamber authorised the prosecutor to proceed with the investigation into the situation in Bangladesh/Myanmar for crimes against humanity committed against the Rohingya, specifically the crime of deportation. So as Rosemary mentioned earlier, the chamber held that although Myanmar was not a party to the Rome Statute, Bangladesh was, and as an element of the crime of deportation, the expulsion of the Rohingya across the international border from Myanmar to Bangladesh was carried out on the territory of the state party, the court had jurisdiction to investigate deportation and perhaps other crimes against humanity related to deportation as well, such as persecution. Because of the jurisdictional limitation, it would seem that the ICC can't investigate genocide, which is what most Rohingya seem to think is what the military intended when they rampaged through villages in northern Rakhine, machine gunning families, raping women, and burying the bodies in ditches. So the ICC investigation is underway. ICC staff have visited the camps in Bangladesh. They've spoken with communities. Expectations about justice have been significantly raised, as have levels of confusion within the Rohingya community in Cox's Bazar, as between the different mechanisms and courts currently addressing the atrocities committed against them. The ICC registry this year reported that the overwhelming majority of people have very little information and understanding, if any, of the various justice initiatives, and importantly, their different mandates and functions. In June last year, victims' representatives filed a notice in the ICC registry requesting a change of venue from The Hague to Cox's Bazar in Bangladesh, which is where 750,000 Rohingya refugees currently live. And the ICC registry's noted this and is considering it. Bangladesh is involved as an amicus and has submitted a confidential report to the court. So the genocide case against the military is left to a third set of international legal proceedings in Argentina, where in November 2019, the Burma Rohingya Organisation UK commenced a case under universal jurisdiction against State Councillor Aung San Suu Kyi, Commander-in-Chief Min Aung Hlaing and others for genocide. Early last year, this case ran into problems when an Argentinian court dismissed it on the grounds that the International Criminal Court was already looking at the issue. But in May last year, an Argentinian federal criminal court overturned that decision and instead requested advice from the ICC as to the scope of its investigation in order to determine whether substantially the same ground was in fact the subject of the two different sets of proceedings. We don't yet have a response that I'm aware of to this, but it raises some difficult questions concerning complementarity. The obvious point are that criminal proceedings in Argentina are unlikely to give victims the access to justice that they desire and which is their right. And then, of course, there's the question of what prospect Argentina has of bringing General Min Aung Hlaing or Aung San Suu Kyi, or any of them, before an Argentinian court. So last year, I spoke at this conference, and after describing what were then quite preliminary international proceedings involving Myanmar, I asked a couple of questions. And it's interesting to return to two of these in particular and see what the answer is a year down the track. So the first question that I asked was whether what we had here was a patchwork of functional accountability, the international community holding Myanmar, the state, accountable for genocide in the International Court of Justice, while it holds individuals accountable in the International Criminal Court for at least some of the crimes for which they're responsible, and at the same time, other crimes for which jurisdictional reasons the ICC can't touch, genocide, are brought by states like Argentina under the principle of universal jurisdiction. And I said, do we have, in the face of Security Council intransigence, creative lawyering in the cause of accountability and ending impunity? And that's exactly how proponents and defenders of international criminal justice have portrayed the Myanmar proceedings. And the second question I asked was about the larger goal of peace and stability in Myanmar. I said that the best political science evidence we had about the effects of criminal prosecutions in transitional justice contexts like Myanmar say that only prosecutions of low and middle level human rights violators are associated with a decrease in the likelihood of conflict recurrence. In contrast, pursuing the prosecutions of high-ranking actors, like those identified by the UN fact-finding mission and named in the Argentinian proceedings and presumably under investigation by the ICC, makes conflict recurrence more likely. I said that in relation to Myanmar, we could put the odds of violence following attempts at prosecution of high-ranking actors higher than that, given Myanmar's history of past coups. And before February 1 this year, the military was constitutionally embedded in the political power structure of the state. And now, after 1 February, it effectively is the state. So in the last few minutes, I'll hover over 3 specific issues related to the cases. The first concerns evidence. In September last year, a slightly bizarre thing happened. 2 Burmese army privates, Myo Win Tun and Zaw Nang Tun, deserted the Burmese army and ended up in Rakhine State with one of the armed ethnic organisations that their own army had been fighting, the Arakan Army. The Arakan Army taped the confessions of the 2 deserters, which included admissions of mass murder and the destruction of entire Rohingya villages under orders from senior officers. The privates then arrived in Bangladesh seeking protection. ICC investigators heard about them, and the 2 were handed over to the Dutch and taken to the Netherlands, where they remain in the care of the Dutch government, not in the custody of the ICC. The government of Myanmar, through a military spokesperson, dismissed the confessions, called the Arakan Army a terrorist organisation, and said that the former soldiers had been coerced into giving these statements. But we can imagine the ICC's excitement at finding the 2 deserters, because the question of evidence is a big problem for all these proceedings. Myanmar is not cooperating. The preliminary measures in the ICJ were ordered on the basis of factual material gathered by the independent international fact-finding mission set up by the Human Rights Council in 2018. The IIFM was not permitted to enter Myanmar, was not given access to locations of alleged massacres or other atrocities, or government officials who might have ordered them. Evidence primarily came from refugees outside Myanmar. Although the mission used best practice to establish the veracity of evidence, It did not claim to establish facts to the criminal standard of proof. Evidence wasn't tested in an adversarial setting. And Myanmar challenged the credibility, completeness, and impartiality of the mission's evidence and established its own fact-finding body that reached a totally different conclusion on the genocide question, at least. Now, the ICJ accepted the mission's findings for the provisional measures stage of proceedings, but it won't be able to do that on the merits stage. As we know from Bosnia and Serbia, a more taxing evidentiary burden applies, as it should, given the nature of the allegations that are being levelled at the state through its agents. In Bosnia and Serbia, the ICJ was able to accept factual findings made after criminal trials at the ICTY. In those cases, the ICJ's findings on genocide in relation to Srebrenica rested on ICT findings in cases like Christic. But in the Myanmar case, without decisions handed down following criminal trials, there will be a big evidence problem at the ICJ. So what about the prospects in those criminal proceedings, the ICC proceedings and the Argentinian Universal Jurisdiction proceedings? It's possible that we have a fascinating and tragic situation where the ICC's attempt to expand its jurisdiction makes the Argentinian court's efforts to bring a case under universal jurisdiction not in fact complementary, but incompatible because of lack of clarity about what precisely the scope of the ICC's case is. We know that in its decision on jurisdiction, the pre-trial chamber opened the door to the prosecutor to widen the ambit of her investigation from deportation to other crimes where part of the conduct may have been carried out on the territory of Bangladesh, such as persecution or other inhumane acts of a similar character intentionally causing great suffering or serious injury to body or to mental or physical health. But there's uncertainty and a lot of debate about whether the decision opens the door for the prosecutor to investigate crimes beyond Article 7 of the Rome Statute. The prosecutor stated that she would examine a number of coercive acts that led to the forced displacement of the Rohingya, including deprivation of fundamental rights, killing, sexual violence, enforced disappearance, destruction, and looting. Some people have argued that the pre-trial chamber's decision also permits investigation into genocide, at least in the form of Article 6C of the Rome Statute, deliberately inflicting conditions of life calculated to bring about physical destruction. The argument here is that the circumstances of the Rohingyas' deportation to Bangladesh and what the Burmese military knew awaited the Rohingya over the border, hunger, disease, and COVID-19, lend itself to this characterisation. And there are a couple of responses to this. First, on the ICC's extension of jurisdiction to a non-state party that Rosemary asked about earlier. It's troubling on policy grounds because the legitimacy of the court rests on the consent of state parties. On legal grounds, the case for extending jurisdiction rests on the argument that the conduct in question in the crime of deportation extends to the territory of Bangladesh, a state party. The foundation for that argument is not as strong as one might think. For one thing, because the Rome Statute distinguishes between conduct, consequences, and circumstances, and it's possible that displacement to Bangladesh was a consequence rather than conduct. In relation to the further step, the possibility of expanding the crime of persecution and deportation to genocide, we have no precedents. From the ICTY, we have statements from the court that although ethnic cleansing and genocide are different things, ethnic cleansing can sometimes, under certain conditions, become genocide. But in actual fact, on the few occasions where courts have found genocide, it's been on the basis of large numbers of killings within a constrained period of time. So I think here is just to remind you of how tricky things get when we don't have the cooperation of the state in bringing someone before the court. Omar al-Bashir obviously still hasn't faced the ICC. So the outlook, in summary, was horrible for the Rohingya before the 1st of February. It's much worse now. The prospect of a reformed state committed to democratic values is further away. The fact that Myanmar's current head of state is on notice that he could be held accountable for crimes committed in Rakhine State means that he's even less likely to let go control of the state.
It's not immediately apparent to me that we still have Emily with us.
Oh, we do.
Oh, beautiful. There we go.
Good morning, everyone. Delighted to be here. I was on the beach in Byron Bay yesterday, and if it's a choice between coming to this conference and staying in Byron, of course, an international law conference wins, hands down, every time. I'd like to give you a bit of a snapshot of developments in international counter-terrorism over the last year and a bit, and highlighting a number of key cases and some key legislative developments at the international level. First, though, I thought I'd just give you a flavour of the impact of the COVID pandemic on terrorism and counter-terrorism, starting with ISIS, the Islamic State, which was flat-footed by the coming of the pandemic and struggled to formulate a response. It started by saying to its followers, don't go to Europe and the United States because it's too dangerous there. Stay away from the lands of the epidemic. And then it went on to give a whole lot of public health messages. Cover your mouth when yawning and sneezing, wash your hands frequently, and it's a holy obligation to avoid illness. The pandemic then, in some ways, dampened prospects for terrorism by ISIS and fellow travellers because lockdowns limited opportunities for attacks on soft targets. There were concerns that fighters on the battlefield would get sick, just like Western militaries were concerned when whole aircraft carriers got sick. But then soon ISIS decided to take advantage of the pandemic. Firstly, it created a narrative that the pandemic is a plague on the West and on China, interestingly, for oppressing Uyghur Muslims. So terrorism is a response to genocide, according to Islamic State. It then said its followers should spread the pandemic because as believers, they won't get sick. So a virus denier element there, called the virus God's smallest soldier as a way of attacking foreign states. Really, the methods which ISIS then began to use in pandemic times transformed from physical or kinetic attacks to instead taking advantage of lots of people being at home on their computers and pursuing cybercrime strategies to raise money, to recruit people stuck at home to take advantage of these captive audiences. It also sought to take advantage of states being distracted by the pandemic and money being diverted from counter-terrorism and military responses into public health responses. And it also drew on the narrative that poor public health responses exacerbated existing grievances and inequalities, which are conditions conducive to extremism and terrorism, according to the United Nations. Final point on pandemic is just that we did see a kind of spread of emergency counter-terrorism type measures into the public health domain. So the use of special powers, exceptional powers to police populations during the pandemic, this kind of securitization of public health became one feature in some places. Okay, next topic I want to address is just a couple of key decisions worth mentioning over the last year or so. One was at the end of 2019, which was the preliminary objections decision in the case of Ukraine and Russia before the International Court of Justice, which was a case brought under the dispute settlement provisions of both the racial discrimination, Convention again on the elimination of racial discrimination, but also, for our purposes, the Terrorist Financing Convention of 1999. And the court made two quite important rulings on the Financing Convention. Firstly, it held that the Financing Convention does not provide for state responsibility for the commission of terrorism, as Ukraine had argued, by analogy with the Genocide Convention, because the obligations to prevent genocide and to criminalise genocide led in previous ICJ decisions to a finding that the state itself can be responsible for committing genocide. Here, the court drew on the differences in language and purposes of the different conventions and said that the Financing Convention is purely a criminal suppression instrument. In other words, it only establishes individual criminal responsibility of, quote, any person. Russia argued that any person only means any non-state person, not state officials. And on that front, Russia lost. The court said, yes, there's no state responsibility for committing terrorism, but if state officials commit it, they are any person and therefore can be held individually criminally responsible. It just means that Russian officials who commit it, it doesn't make Russia, the Russian state, responsible for their conduct. It went on to say, though, that other obligations under the convention are still relevant in this regard. So a failure to suppress terrorist financing by state officials could separately give rise to state responsibility for a breach of the treaty obligation to prevent terrorism and also the obligations to prosecute or extradite anyone, including state officials, who commit it. Secondly, and this was all in the context of Ukraine accusing Russia of financing rebels in the war in eastern Ukraine. The second issue, the court left to the merits. That was whether the offence of providing or receiving funds, which is the essence of terrorist financing, extends to non-pecuniary assets, such as Russia's arming and training of terrorist separatists in Ukraine, as Ukraine argues. So Ukraine's not saying that Russia gave money to the rebels in eastern Ukraine, but it is saying it gave weapons, other forms of military logistical support. And because the Terrorist Financing Convention defines funds to include, quote, assets of any kind, whether tangible or intangible, movable or immovable, read literally, that could cover any object of value, not just money or money equivalents, but goats, camels, anything that anyone gives to a terrorist or a terrorist organisation, and thus operate actually as a kind of US-style material support provision. Anything you give to terrorists is terrorist financing, even though this may seem counterintuitive from a literal understanding of a convention, which is called the Terrorist Financing Convention, not the Material Support Convention. Russia didn't object to it at the jurisdiction phase, so it was left to the merits, and all the court said was that the definition covers many kinds of financial instruments, but also includes other assets. So there's a debate here, and in state practice, opinion is quite divided on this. Some states take a more restrictive view, limiting it to financial type instruments. Others include camels, goats, anything you give to a terrorist. Second decision I draw attention to is the long-awaited trial judgment of the Special Tribunal for Lebanon in August last year, which I have to say ended with a whimper, not a bang. Only one person, Salim Ayash, was convicted and was sentenced in absentia to 5 life terms of imprisonment for committing effectively a whole bunch of murders and terrorism, so 2 sets of charges. Murder of 22 people and 226 injured, convicted of attempted murder on those counts, in the massive terrorist car bombing of the former Lebanese Prime Minister Rafiq Hariri in 2005. Ayash was found to be associated with Hezbollah, but there was no smoking gun to link him to the Hezbollah leadership or to the Syrian government, despite the court noting that both of those parties certainly had motive to commit an attack like this. The case was super complex. The judgment runs to 2,600 pages. There were 1,500 court decisions in the 12 or so years that the trial ran, 406 trial days. And most of the case actually was based on circumstantial analysis of mobile phone intercepts, 1,000 pages of discussion of mobile phone intercepts, which is important because this is also the kind of evidence that's being investigated very heavily by the UN mechanism for Iraq, trying to convict based on social media posts and so on, what members of ISIS did in Iraq, and also of relevance to Syria. In terms of the legacy of the tribunal, the Prime Minister's, the Rafiq Hariri's son, also a former Prime Minister, Saad Hariri, praised the judgment as sending a message to the killers that the era of political crimes is over in Lebanon, but he conceded that more justice needs to be done to break the cycle of violence. So the conviction is something in a country where more than 20 senior politicians have been assassinated in the last couple of decades. Even one of the key intelligence officers of the Lebanese state, who shared intercept analysis with the UN, was soon killed himself in a car bombing after he did that. The tribunal's also been feted for outreach activities in Lebanon, which raised awareness of human rights and international justice within Lebanon. On the other hand, the outcome is disappointing with the virtue of hindsight. The little justice that was done took 15 years and cost $1 billion to convict one person, including a bloated bureaucracy of 400 court staff in The Hague. Despite the high cost, there was no money to compensate victims. Legally, its controversial pronouncements about the existence of a customary international law crime of terrorism were irrelevant to the trials. And the precedential value of the tribunal more broadly is fairly limited, because its jurisdiction is mainly based on Lebanese domestic law, with a bit of modes of liability under international criminal law thrown in, so joint criminal enterprise and superior responsibility. It did make contributions to the jurisprudence on fair trial in absentia, because the 5 persons charged, none of them were before the court, and none of them have ever been found. One guy is presumed dead. But defence counsel, even on this front, maintained that none of the defendants knew of the trial or were reasonably informed of the charges. Hezbollah refused to cooperate at all, and its influence in Lebanese politics muted the tribunal's potential from the start, as did the wider schisms in Lebanese politics, with the Lebanese parliament refusing to approve the tribunal and the Security Council having to establish it by fiat at the request of the Lebanese Prime Minister, who didn't control the parliament. The remoteness of the seat of the court at The Hague limited its impact inside Lebanon, while the politics within the court, including one judge suing the court for not getting selected to sit on another of its cases, were unhelpful distractions. The focus on individual responsibility excluded broader transitional justice objectives like truth-finding, accountability, and reparation. Meanwhile, Lebanon had moved on, with the events 15 years ago overshadowed by successive political and economic crises, the war in neighbouring Syria, the Beirut port explosion, leaving 300,000 people homeless just a couple of weeks before the judgment was announced. But nonetheless, the tribunal still plods along. Our friend Salim Ayash was charged with more offences in late 2019 for other attacks on politicians in 2004-05, and his case will also be subject to an appeal. At the legislative level then, I just wanted to highlight a few of the key debates which are going on internationally at the moment. Sticking with the theme of this panel on criminal accountability, one big issue is the interaction between prosecuting offenders for terrorist crimes as opposed to charging international crimes like war crimes or crimes against humanity or genocide. This is an issue at a whole bunch of levels. Obviously, at the ICC level, there are charges potentially against the Taliban in the Afghanistan situation, against Hamas in Palestine, and of course, for those states which oppose the court looking at the Palestine situation, those states were also opposing the International Court prosecuting terrorists for firing indiscriminate rockets at civilian populations. So it is, of course, a two-way street. The UN mechanisms for Syria and Iraq collecting evidence there are also looking to find evidence of crimes. And then there are a bunch of national or sub-national justice processes on foot. So dozens of universal jurisdiction cases in European countries in respect of Syria and Iraq. The Syrian Democratic Forces, a non-state actor, has charged and convicted thousands of Islamic State personnel in non-state courts in northeast Syria. And in Iraq, tribal justice is meting out collective punishment, banishment, exile, etc. for former ISIS fighters. So the debate here goes like this. Some states very strongly believe that you should lock up terrorists by pursuing the easiest prosecutorial strategy possible. Counter-terrorism law has clear advantages over international criminal law in this respect, because terrorism offences are defined so widely to include so many preparatory and status-based offences like membership of a terrorist group, that you don't have to show that the person actually did anything harmful, you know, that you murdered a prisoner or committed some other violence against a civilian. The preparatory offences in particular give you a whole lot of legal tools which international criminal law doesn't give you, because the modes of liability under international criminal law are not as preventive or preparatory as those under counter-terrorism law. Virtually all states have terrorism offences, whereas a surprising number of states do not have international criminal law offences in domestic law. Counter-terrorism law has well-developed obligations in respect of international cooperation in extradition, prosecution and prevention, whereas international criminal law treaties and custom are much patchier with some exceptions. Counter-terrorism law gives you much stronger special investigative powers of surveillance, intelligence, detention and so on than you get under international criminal law, which follows a much more conventional, traditional model. Counterterrorism prosecutions are really familiar to law enforcement in many countries because they've done lots of these trials, where most countries have never prosecuted international crimes and are really unfamiliar with it. And also, as one Egyptian prosecutor said to me, actually the guy who prosecuted Peter Grester in Egypt, you know, penalties are heavier for terrorism charges than they are for war crimes. So why would we go down a route which lets you get a lesser penalty? On the other hand, the flip side of the debate is that international criminal law also has certain advantages in its own right. Its crimes are universally defined, which you can't say for terrorism offences, which are much more subjective at the national level. It criminalises certain harms which aren't reflected in terrorism charges, like the special intent to exterminate, that's part of genocide and other elements of crimes against humanity. Charging terror, if you charge someone for membership of a terrorist group, that just doesn't reflect the gravity of their conduct if they've been going about the battlefield killing captured soldiers. International criminal law expresses the international community's universal condemnation at this expressive level. Charging international crimes gives a better sense of justice for victims than potentially only charging as terrorism. And there are also various modes of well-trodden paths of international cooperation for international crimes, at least between certain groups of states. Penalties can be higher, and finally, there are international procedures you can access which you don't get for terrorism offences. Not only the International Criminal Court, but various human rights law and IHL bodies which can give remedies off the back of breaches of international criminal law. Okay, I think I'll finish up by just saying something very briefly about the title of my talk, The Never-Ending Global Counterterrorism Juggernaut, and that is that we've seen a second wave of global legislating against terrorism since 2014, when ISIS arose. So the first wave was 9/11 and the decade or so after that, and then an intensification or renewed lawmaking at the international level in the last 5 or 6 years. It's happening at 2 levels. So like post 9/11, it's the level of the Security Council making binding obligations on all states, often in very detailed ways. But what we've increasingly seen in the second wave is the proliferation of soft law in a way which is quite frankly going bananas. You've got new counterterrorism bodies like the 30+ member state Global Counter-Terrorism Forum, led not only by the US, but other great powers as well, literally every month issuing very lengthy, detailed guidelines on a whole range of very detailed legal matters. Airline passenger data and biometrics, border controls, battlefield evidence, prosecution rehabilitation strategies, foreign fighters, preventing violent extremism, you name it. Every issue under the sun is being addressed by those guidelines. What's the problem? The problem is really twofold. One is that these bodies lack virtually any meaningful civil society participation. Processes of lawmaking are opaque and not at all transparent. Secondly, often human rights issues are glossed over in a single sentence or a couple of sentences in a really tokenistic manner. And that's in contrast to the vast technical detail which these guidelines provide states in relation to the counter-terrorism matters which they're dealing with. So the UN Special Rapporteur on Counter-terrorism and Human Rights has been deeply concerned about this proliferation. Why does it matter? Even though it's soft law, it often becomes hard because after a year or two, the Security Council picks it up and makes it binding because its members of the Global Forum are P5 members and so on. Or alternatively, it stays soft, but it's treated as hard by the international mechanisms which have mandates to monitor and supervise counterterrorism implementation. So that's the UN machinery at the Security Council, plus bilateral technical assistance provided by multilateral or bilateral partners. There's also a delegation of compliance according to these standards to non-state actors like banks and charities and so on, which are expected to implement this kind of stuff. $100 million been given to the UN counterterrorism machinery by Saudi Arabia and some other major donors. The senior leadership positions in the UN architecture are now held by Russians and Saudis. So there's a tussle going on between like-minded human rights respecting states on the one hand, and on the other hand, those states who wish to emphasise a harder line on counter-terrorism within the UN machinery for control of what standards are set and how they are implemented. Meanwhile, the human rights bodies are valiantly trying to push back whenever they can. And to conclude, I'd just point you to a super interesting decision by the Committee on the Rights of the Child in September last year, LH and FB against France, where the committee said, look, France's human rights obligations apply to French children in Syrian Islamic State camps, displacement camps. Those children are within French jurisdiction, even though France has no territorial or personal control over them, which is the standard line on jurisdiction in human rights law, because France has a consular power to make decisions affecting their fate, which can affect the protection of their human rights. So they said, because that consular power exists, it entails the French state's effective control over those children, at least in circumstances, and they painted the circumstances as fairly narrow. These children are, number one, extremely vulnerable, and number two, their lives are at imminent risk. So at least in those circumstances, a more expansive understanding of jurisdiction has been established. And I would suggest to you that that's quite a path-breaking jurisdictional decision, contrasts heavily with Georgia and Russia in the European Court of Human Rights, another recent decision which basically said human rights don't apply on the hot, chaotic battlefield, even if you have the capacity to affect the right to life through your lethal military operations. Thanks.
So we have a little bit of time for questions, and I think probably just for convenience sake, I'll intervene with the questions that are being put through the chat on Zoom, but I might just ask Ben and Catherine to respond to questions in the crowd directly. But I'll start off. We do actually have a question for Catherine in the Zoom chat, where someone said, thank you very much for your presentation. Could you please point us to the research that says the conviction of low-level security force personnel helps prevent future violence, but that the prosecution of senior personnel exacerbates it?
I can. It's literature that's really common in political science and including in the International Journal of Transitional Justice. They've done small N studies of countries using the Latin American experience and the African experience in particular of the consequences of prosecutions at different levels. And while that hasn't been applied in Asia to the same extent, the argument's still strongly made that if the interests are peace and stability, then amnesties are the first port of call.
Okay, do we have any questions from the room? Please feel free to send them through online, or if you have them in the room, just put your hand up and Catherine and Ben can respond.
No one is asking questions here in the room.
Not seeing anything. Catherine, is there anything in the room?
Hi, sorry, Emily. There's no questions in the room, so feel free to go to the next one on the chat function if you'd like.
I don't think we have any more coming in on the chat function. There was just that one. So I think that might be it. My apologies for not being in the room, so I'm not able to assess whether lunch has turned up or not in time. But
I might ask one question then myself, if I may. It's Rose here. Catherine, I wanted to ask you a little bit if you could elaborate on that evidence question. What do you think will happen if there are no criminal proceedings prior to the ICJ having to decide? Can the ICJ, for example, rely on the evidence that the ICC prosecutor has submitted in the absence of a judicial decision, or the fact-finding report, or what do you think will happen to fill those evidence gaps in the ICJ?
So we're not sure, but in Bosnia and Serbia in the ICJ, the court did rely on some investigations and reports that had been carried out ordered by the Security Council. So they said that the reports had a high degree of veracity because of the impartiality and independence of the investigators, but they didn't rely solely on those reports. So they also did rely heavily on the findings of criminal proceedings. So some people are saying this is a jurisdictional race between getting some criminal findings that the ICJ could rely on, but it's not, the ICJ is certainly not a criminal court, etc., but it's not beyond the scope of its powers to, for example, cross-examine the people who put the fact-finding mission report together. And so that's the suggestion of what could happen in the event that we don't have any criminal findings to rely on, that you examine the methodology of the report, and on that count, the Independent International Fact-Finding Mission used all of the best practice procedures that have been built up now for quite a long period of time to test and cross-check the evidence that they put together. A lot of it is confidential and appended to its report, but there's no reason why the ICJ couldn't have access to that. And there's also an ongoing fact-finding body established by the Human Rights Council to continue gathering and collating evidence as well. So that could be another source of findings for the ICJ.
Well, there are no more questions that are coming through on chat, and unless we have any other questions from the room, I think we can wrap things up for this session, and it just remains for me to thank our two presenters, Professor Ben Saul and Professor Catherine Renshaw, for a really interesting look into some of the major issues in international peace and security in the last year. So if you'll join me in thanking them, and then you're welcome to enjoy lunch, and we'll hand over to our literary lunch guest and presenter. So thank you so much, Catherine and Ben.
Thank you, Emily. And I just wanted to also extend my thanks to Emily Crawford for giving that incredibly perceptive briefing on the Barrister report, and welcome everybody in the room and also on Zoom to rejoin us at 12:30 for the literary lunch. So thank you.